Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning, everyone. Welcome to Thursday Tips with LAWPRO. I'm Joan Rataic-Lang. I'm the Executive Director of the Toronto Lawyers Association, and I would like to recognize that Toronto is in the dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans and all newcomers, have been invited into this treaty in the spirit of peace, friendship, and respect. Today, we have people from all over the province watching. The TLA respects and affirms the inherent and treaty rights of all Indigenous peoples across this land. Now, before we get started, let me make a few quick pitches for some things that are near and dear to me. First off, there are 47 county courthouse libraries across the province. If you're not a member of your local association, consider joining. Use the courthouse libraries. In many cases, the doors are open. Here in Toronto, you don't have to be a member to walk in and use the resources that are available to you. We also get a lot of phone calls and emails. The faxes stopped a few years ago. But anyway, there are many ways you can reach out to us, and we look forward to helping you with your research needs. And I'm sure the librarians across the province would all say the same thing. The TLA is very proud of the relationship we have with LAWPRO. Judah and I work closely together to bring lawyers in the province, lawyers and paralegals in the province, all sorts of useful education programs. And I'm really excited about this new series, Thursday Tips. So today, it's family law that we're covering. Before the summer, we'll also be doing a program for advocates and wills and estates, and then 3 more in the fall. We hope that we'll see you again at some of these other programs, or you tell people about them if they're not in your practice area. Finally, I just want to invite those of you who are in Toronto to the TLA's Awards Gala on May 10th at the Steam Whistle Brewery. It's going to be a lovely event. We have some wonderful people that we're honoring, and Louise Arbour will be receiving the Award of Distinction. So we know that the speeches will be interesting, and the food will be great. The venue is lovely. I'm planning a super event, so hope to see many of you there. You're done with me now. I'm going to turn it over to Judah. He will answer, I think, some of the questions because I've seen raised hands and questions about being muted. He'll take care of everything from here. Have a good program and a lovely weekend.
Thank you so much, Joan, and thanks as always to the Toronto Lawyers Association for hosting in partnership with LAWPRO these risk series. And thank you for that important land acknowledgement at the outset as well. Just a quick logistical piece. I see some people are wondering, am I supposed to be muted? Viewers are on mute today because we've got over 300 of you with us right now. But if you have questions, just put them in the Q&A icon and we'll try to get to as many as we can today. So welcome everyone. I'm Judah Strivchinsky. I'm the Director of Practice Pro, which is LAWPRO's Claims Prevention and Risk Management Program. Again, thank you for taking time. I know everyone's swamped. We have a long weekend coming up. Everyone's got all sorts of priorities. So we value your time and we thank you for giving some of it to share this space with us today. Today on Family Law Tips, it's part of our recurring Thursday Tips series, and we're going to tackle 3 areas of discussion. So the first is we're going to cover risk trends that we've been seeing recently in the family law area. Next, the second, we're going to drill down into some of the key client management and client communication issues. Spoiler alert, in family law, client communication is the #1 risk area. And third, we're going to talk about tech and tools available to help you improve your family law practice, especially as we pivot from whatever space we're in right now in the middle of an ongoing pandemic to whatever our next normal is going to look like. So we've put together written resources for today's program. For those attending live, they're going to appear in the program chat. They're also going to be available, or sorry, they're already available for download at practicepro.ca/CPD. And then if you click on today's program, you'll find that there's a supporting material link where you can download. So we've got amazing speakers. I'm not going to introduce them. I'm going to let them each say hi and a little bit about themselves when they first speak, but you can learn more about each of them through their bios, which are in the program materials. So let's start. Let's start with the risk management piece. And before we get to our first theme, I just want to point out that in your materials, the first take-home piece is a 2-pager that you can also find on practicepro.ca that has what I lovingly call LAWPRO's Wheels of Misfortune. You've seen them all if you've spent any time with us in the past. The wheels are pie charts that show you where, by area of practice, mistakes happen or people have to report to LAWPRO with a claim, even if nothing has gone wrong. What's the primary issue? We've been doing this as your insurer since the 90s. We track it over time. And so those pie charts that you see show a 10-year frame. What have been the biggest pieces over time? Anyone who's seen me speak knows that I tell people that we are, as lawyers and as law clerks and others, we are all in the legal services field. Legal services. In most areas, we've gone to law school, we understand the law, we understand how to dig deeper for the law. The legal is actually only the 4th biggest risk area. The services side is where the mistakes happen because we never got that training. The services are communication, time management, and investigation. So managing your client's expectations and communications generally, digging to understand a file, and managing the time on a file. For family law, though, family law is super complex. And so communication is by far and away the biggest pain point. I'm sure anyone who spent any moment on a family law file can relate to that. But the second issue is actually the mistakes in law. And that's because family law is really complex. It touches on federal jurisdiction and provincial jurisdiction. It's got 2 levels of court. Sometimes they live in a unified fashion, sometimes they don't. The law is evolving always. We've seen the Divorce Act changes, for example. And so today we're going to focus on some of those risks. But if you are new to family law and trying to understand where are the areas where I should be slowing down, where are the areas where I should be focusing in, go look at the Wheel of Misfortune so that you can focus on a practice-based best practices and grow your practice based on knowing where the risks are. So when we think about the risks, I know that some of them have been different through COVID. Many of them are twists, rapidly changing laws or rapidly changing court processes, but there are some also very new risks. And so I'm going to ask Michael to say good morning and talk to us a little bit. But before we get to him, he's going to talk about some of those gaps in the law and kick us off on that. But before we get to that, I want to talk isolation during COVID and where we're at as a community, where we're at as a profession, because this is a risk area that we're actually seeing in LawPro. So Kelly, maybe you can start us off and say hi.
Hi, everyone. Good morning. It's funny, we in preparation for this talk, we talked about, how COVID has impacted on isolation for lawyers. Most of us practice in solo or small firms to begin with, and then you add the pandemic and quarantine, and we're even further isolated. And I see a lot of, chat in the Ontario Family Law Facebook page of people reaching out for mentorship, etc. I, in my own firm, just finished a 2-week trial, which was quite interesting because it was a Zoom trial and we did it from our office. And it was a way that I was able to mentor my associates in a way that I couldn't have if they were doing their first 2-week trial in court in person. So it offered an opportunity for mentorship that we don't have. So COVID brought some challenges, but also some opportunities for mentorship. And that's really what I've noticed in terms of the isolation.
Okay, and then Michael, I mean, you're in a firm that's pretty diverse in terms of the age and stage of people. How are you finding it's impacting in terms of how you're getting the work done and how things are moving around in your office?
So we're functioning It is difficult. And, there's a couple things I've noticed. I may have problems because my Zoom just said my internet connection is unstable. So if I pause, I apologize. It takes you kind of have to actively seek out people to get mentorship in a way that you might not have had to do when we were at the courthouses or when you were in the office every day, even if you were on your own, if you had people in the office. So it's, we have in my office, we have 2 times a week, we have firm-wide Zooms to just check in with people and talk. And, we've really worked on, or at least it's coming along, trying to have a more formal mentoring program because, in the old days in my office, if you were an articling student, half of your year would literally just be following the late Phil Epstein around. And that was, an unbelievable mentoring experience because you learn through osmosis. But that really, I'm not sure how available that is, but, it's anymore, or, how many people get those opportunities. So it's really, if you're a young lawyer, it really is critical to try to find somebody that you have to bounce things off of that you can trust. And it's hard to do, and it's hard to find those people, but it's really an invaluable thing to have, even if you're, don't maybe consider not being in an office totally by yourself and being in a law chambers or things like that. You can't do this work without having people to run things by because it's just too complicated. It's just, there's too many judgment calls involved, and you really need that support system in place. It's critical.
Yeah, and we can even see, we've got people in the comments saying it's been hard to start a new practice during COVID for sure. And we get that. And it's been hard for everyone. I know that there are some senior members of the bar who have decided to retire a bit early because this is not how they enjoy practice. We've seen people have to step away for leaves and elsewhere. One of the things about social isolation, and even before social isolation really, that we've seen is there are communities of practice that are available online. And there are some real benefits to those, but there are also some risks. Maybe I can start with Kelly again about some of the communities that she's seen and how they've been working.
So I certainly am an avid follower of the Facebook group that I mentioned a second ago. But that poses some challenges too, because that's not a confidential group, and reaching out, your opposing counsel could be also on the other side. You don't know that the group has hundreds of members. So it's how do you reach out in a way that is helpful and provides you with some mentoring, but do so in a way that's safely and doesn't jeopardize any kind of liability issues. So I encourage people to develop their own mentoree relationship, sort of confidentially and outside of that type of group setting.
Yeah, that makes sense. And Yvonne, I know that you've seen the Facebook group from time to time, and Facebook groups are great. We know that we had this actual event promoted through one of the family lawyers' Facebook events, and people were registering even before we started our formal marketing. So clearly there are benefits to the networking, to making those connections, to seeing who's doing what in family law. Yvonne, what are some of the higher risk things you've seen, without naming names or anything? What are some things that here at LawPro we look at and say, oh dear, that might come back in a way that might be unexpected?
If you're asking specifically in the context of Facebook groups and sharing of information, you have to be very concerned about maintaining confidentiality. So there's you have to be very, very careful of what you can disclose in a Facebook conversation, because you may be disclosing information that will enable other people to identify who you are talking about. And that is a breach of your obligation under the rules of professional conduct to maintain confidentiality. Personally, I have always felt that one of the best ways to find people who you can look up to and be guided by, and who you can try to establish a mentoring relationship or something akin to a mentoring relationship, is by attending CLE programs, because by attending CLE programs, you see who are the speakers, who are the people who are knowledgeable in this practice area. And my experience is that experienced senior lawyers are usually quite happy to talk and to share information. And it's a really important way to establish contacts with people in the profession.
For sure, that's an important way, and you know, part of that in this day and age involves going almost analog. Facebook is great, LinkedIn are great. There are lots of online tools. You know, Facebook is a great way to reach out and make a connection, an actual connection. But then you want to take it private, and sometimes that involves picking up the phone, and that can be daunting. But new calls, just so you know, like we've all been there, and if you're looking for a bit of a learning opportunity or the ability to go and pick the brain of somebody more senior to you. My experience getting into the profession was that when you are aware of what somebody's done, perhaps you've checked a few of their reported recent cases or seen them at a CPD, if you follow up with a note and ask if they have a few minutes to chat, they are very welcome and very happy to do so. Jennifer, perhaps you can talk a little bit about how that vine swinging occurs in real life.
Yeah, no, like I'm part of a firm. I'm a partner at Wood Gold. We have 9 lawyers altogether. And so the benefit of the firm is that we can share collective knowledge and meet regularly. But if you're working on your own or in small practice, you can create a community yourself. And I know of some lawyers who've done this, who have gotten together maybe with 3 or 4 other lawyers and meet regularly. So, and that's something you can, you can do by connecting initially on Facebook and meeting some of the members in that community, but taking it further to maybe a regular meeting where you can talk about issues and work that through. And ideally you have a diverse group in terms of practice experience or specialty. Someone referred to that, I know, as a mastermind group. And so that's something you can do because even as, a lawyer, I've been practicing for more than 20 years. Family law is so complex and changing. And so I really benefit from other lawyers' opinions on strategy or new processes, which we're constantly adapting to.
Thanks, Jennifer. In terms of those who are looking online to find who's who or to meet others in their communities, it's lovely to see the chat group is lighting up live. And these resources, just so you know, there is a Facebook Ontario Family Lawyers group. It's private, but there is an administrator. I'm not going to name who on this session, but there are colleagues of yours who are starting these communities of practice in different ways. There's another one that's being noted in the chat that is a Facebook group for family law lawyers that take legal aid, and it's called Ontario Legal Aid Lawyers. And so we're just amplifying those because finding these communities can be helpful and more often are a great starting point, but the conversations about specific files, as Yvonne would say, or as I would say, they really need to happen offline, and you want to make sure that you're not divulging client information inappropriately. There's another one called Angel Mentorship Group that one of the attendees today has mentioned. In the resources, we're also linking to other programs because, as Yvonne, Kelly, Michael, Jennifer can all attest to, when you see who are the real experts out there, Kelly doing the family law at the Law Society, and Yvonne and others doing the Osgood Professional Development course, you can see who are the people who are really at the forefront of the substantive legal issues and the practice management issues that you need to manage. And there's a steep learning curve and a continuously steep learning curve in family law. So going to those programs and investing in yourself not only will give you a chance to develop your skills, but develop your network. So we've actually provided resources to a few leading family law CPD programs in the materials. They're not provided by LAWPRO, but with TLA's blessing as well, we've put a few in, And of course, you should look to your local law associations for their family law programs that come up from time to time as well. So we're going to just shift focus from the isolation piece and how to network and how do you find your community and how to do so properly, to talk about some of those knowledge gaps, to talk about some of those changes that we're seeing, because we know that there have been not only has there been a pandemic and changes in process, there's also been some significant changes to the Divorce Act, for example. So Michael, I know that you do work across the field here. What are some of the key changes that that you think any family law lawyer needs to stay on top of right now?
So I actually want to be a bit more general than that. So, but before I do that, I want to be blunt about the Facebook group, okay? Because I think it has, just to come back to that for 1 second, I think it has enormous value, and I do check it. But you cannot get, you cannot properly discuss a case and what your strategy might be, or what decisions should be made through Facebook messages. It is impossible. So just don't even try to do that. You can say, does somebody have experience with X and can they talk to me? But don't try to get advice about cases in it. Even if privacy concerns aside, you cannot assess a case by a series of text messages. It's just impossible. So in terms of, legal knowledge gaps and things like that, I think the most useful thing I can offer in a short period of time is to just think about how to assess a case. I wrote down this morning when I was thinking about this 3 questions that I ask myself in every single case, or at least with every single issue, let's put it that way. First, how does the court have jurisdiction to grant the relief I'm seeking? Second, what is the legal test? And third, what facts do I need to prove to meet the legal test? If you can't answer those 3 basic questions to a judge, if it comes up or if you're negotiating, you're not getting anywhere. You can't give advice to your client properly if you can't. Those are the most 3 basic questions you need to be able to answer for any issue. And it's shocking to me how often, even senior lawyers don't have the answers to these questions, because you go into court and the judge says, well, how do I have jurisdiction to order this? You've spent a bunch of money on materials. Somebody said to please repeat the 3, so I'll do that in a second. Somebody, you spent all the money on the materials, you've gone back and forth, and you can't answer the fundamental question of what's the test, what section of a statute does the court have jurisdiction on? So just to repeat those. 1, how does the court have jurisdiction to grant the relief I'm seeking? 2, what is the legal test? And 3, what facts do I need to prove to meet the legal test? So let me tell you how I do this. So if I'm trying to, if you're trying to figure out, and I spent a ton of time doing this when I was more junior and didn't know these things off the top of my head, because, some of these things just stick with you once you figure them out. But there are lots of free resources. So there's, the bar admission course materials are fabulous. They're, it's like Family Law 101 with pretty much everything you need to know, at least at a basic level. There's Ontario Family Law Practice by LexisNexis. If you don't have, I'm not publicizing LexisNexis or a specific product, but it's the maroon book. It's got an annotated version of the key statutes. If you don't have it, you should seriously consider getting it. McLeod's Ontario Family Law Rules, which is an annotated rules. That's by Thomson Reuters. There's the Annual Review of Family Law by McLeod and Mamo, which is by Thomson Reuters. That is a fantastic resource that has every legal issue of family law covered in very, very short paragraphs. Those are all my primary resources, okay? If you want things that are free, there's Canley, and they have they have tons of secondary materials getting added all the time. I would absolutely refer you to Corollary Relief, which is Shmuel Stern's Twitter feed. That is a fabulous way to keep up to date on case law. There's he's also created Court Notice Finder, which is like a drop-down menu way of figuring out what the COVID notices are, and without that, that will save you hours. It's literally impossible to keep track of these things, and Shmuel's done a fantastic service. And quite frankly, I use Google. If I want to know you know, how do I appoint a receiver in family law in Ontario? I might type in family law receiver Ontario. And chances are I'm going to get some sort of hit that at least will tell me where to start. Okay, I do that all the time. And then if you're prepared to buy a paid service, LexisNexis has the Family Law Reporter, and Carswell has This Week in Family Law, which my partner and I author, my partner Aaron Franks. Somebody just said, where will we get a list of all your resources? So I can type that up and we can send that out because I don't have that typed up yet. But my partner Aaron Franks and I author This Week in Family Law. Phil Epstein used to write it and Jay McLeod wrote it before that. It's an easy way to keep up with recent developments in the law. I'm not trying to plug my own thing, but it is a useful way of doing that. We do post free versions of it on Epstein Cole's website about 4 months. They're about 4 months behind, or you can get it at your local law library. But quite frankly, if you're going to do this work, I would get a paid service because, you know, they have enormous value. Westlaw has McLeod's, you know, has the annual review available on it. There's lots of great resources on it, and you need access to this stuff, either in person at the library or online.
Well, that's an amazing whirlwind of the 1.0 when it comes to legal research and managing legal practice and procedure. Those are great resources, many of which even generalists and people who aren't in every day and who doesn't practice family law, I consult some of those from time to time. And thank you, Michael, for offering to put a list together, which we can add to the materials in due course. I will say this as well. If you don't have a paid subscription, I'm going to refer back to what Joan said at the outset. The local law libraries have subscriptions for pretty much any or all of those resources. And it is, these are places that you can use. And even if you can't physically go at the moment, many of the local law librarians are superstars at being able to work with their members. The great library at Osgood is open. They take research requests by email and online. They've got a request form and they are superstars. Across the province, there are unsung heroes helping souls and large firms do that research piece and help you make sure that you can be confident that you're getting to the right answers, or at least getting to the right areas of ambiguity for your clients. And so, you know, that's a really helpful refresher, Michael, and I appreciate it. Yvonne, maybe I can ask you, I mean, it's early days so far. We've seen a few cases come out. The Divorce Act had some fundamental changes around best interests of the child. How is it going so far out there from what we've seen?
It hasn't really had an impact yet, as far as I know, but it's early days because these changes were introduced not that long ago, and we typically see a lag between, you know, when work is done and when a claim materializes. So it's early days. It's too soon really to tell. But it is important to be mindful of those changes and to make sure that clients are mindful of those changes because some of those provisions speak directly to clients. For example, there's a provision which says that orders are to be obeyed until they are no longer operative orders of the court. I mean, that's the kind of information that has to be given to a client, because it's amazing how often clients take it upon themselves to decide that they are not going to abide by an order for what they consider to be very compelling reasons. And part of the lawyer's job is to manage the client's expectations and help them to understand the framework in which we all operate. And you know, one of the pillars of that framework is respect for the judicial system and recognition that an order is not a suggestion and it has to be obeyed until it is no longer the order.
You know, you raise an interesting point there that we see that compliance with court orders sometimes is a really hard piece. You've got to break bad news to a client. You've got to tell them that the court has not given you everything that your client had hoped for, that they're going to have to meet in the middle here, that this is what the court has now declared. We have a paper that actually originally appeared at Osgood's professional development course for family law, but with permission, Justice Himmel and Justice Kurtz have allowed us to reproduce it, and it's called What Not to Do, Common Missteps and Oversteps to Avoid in the Next Time You Are in Court. And one of the things that really struck me, first off, everyone should spend 15 minutes after this program at some point and slowly digest these pieces. And then I'd recommend actually just putting this somewhere prominent and turn to it each time you are considering drafting something or seeking a relief from a court. Use this as a starting point on the things you can and cannot do or should not be doing. But one of the interesting pieces here that they say is the court should not be the first place where your client has heard potential bad news, right? And we're going to talk about client management a little down the road, but that really stuck with me. The fact that the court is getting the impression sometimes, whether it's fair or not, that certain clients may not have understood what they were up against and how things would work. And so a lot of management there. And we have seen some situations where court orders were imposed, and where the lawyer did not take the time to properly explain what that would mean, or might have actually muddied the waters and made things perhaps a little worse. So this is an area for sure to be mindful of. Jennifer, is there anything else you wanted to add around these rapidly evolving areas and some tips for what to focus on these days?
Yes, there's so much to say on this topic. I'm sure we could spend all morning on this topic alone. But I just want to remind people that, in the eyes of the client, you are the expert. So you need to develop expertise. And just like Michael was saying, there's so many resources out there, but you would be surprised how many family lawyers have not read the Family Law Act or the Divorce Act or the rules. Like, if you haven't read the statute, then you're missing potential issues in your client's case. You may not be able to identify them. And then from there, you can branch off to look into further areas of how the cases are interpreting the statute. And another excellent resource, if you're just getting started, and if you are on the legal aid panel, are the legal aid research memos, which are divided by topic. They are excellent, and there's FACTA there as well, and that's free to you if you are on the panel. There are some risk areas that I am mindful of when I'm doing consultations with clients, and some of them are relating to limitation periods, matrimonial home designations, preservation of property. And those are issues, there's issues that you have to be mindful of right at the beginning of the case, sometimes even preservation of evidence, screening for family violence. Like, there are so many issues in family law that if you're not attuned to that right at the beginning, you're going to miss information from the client. You may not provide proper information to the client or advice. And so you really, at the end of the day, have to do your homework at every stage of your career. You got to spend time with the law, with case law and developments, and really raise your expertise to the next level at every stage of your career.
Thanks, Jennifer. I mean, it really is one of those evergreen requirements. And one of the things about that we've all been, that I think is a theme for today, given isolation, given the steep learning curve, is the reaching out and finding your groups. Facebook is the start, but let's talk mentoring now. So we've already talked a little bit about the isolation. That's a risk area. We've talked about the knowledge gaps, which in family law, that's the number 2 area, right? Is errors of law, which means, I know this may sound 101 to some of you who are more senior, but trust us, because we've seen it from senior members of the bar. Going back to basics is really helpful right now, especially when we're all so busy. Coming back to the first principles, checking that you're right on the first principles. These save you time, they save you grief, and they save you potential claims. So that's why we're reviewing those so carefully today. So we've talked about the knowledge gaps, we've talked about isolation. let's talk a bit about mentoring. And we've talked a bit about some of the mentoring that's available. I just want to highlight a few other resources. There is a link in the program resources today, or you can go find it separately on practicepro.ca to a document we put together about this time last year that's on a list of Ontario's mentoring programs. And we put that together because systems navigation is tricky for all of us to find our groups. And no one had put together a list of where there are all these mentoring programs. So we put one together to help you spend less time searching for the groups and more time assessing which group fits you best. So have a look at those groups, whether you're going to be a mentor or a mentee, because there's value on both sides of that equation. Have a look at these programs because there are all sorts of different mentoring programs available out there right now. There are some that are specific to family lawyers. There are some that are specific to female lawyers. There are some that are general for advocates. There are lots of different programs out there, and it's a great way for you to meet other members of the bar and to have a place where you can develop a relationship and learn strategy, learn expertise, and have a sounding board. I'd also want to mention that LAWPRO covers the risk of serving as a mentor. And you can learn about how we do that on lawpro.ca. We basically want to encourage people to get involved in formal mentoring programs where it's a confirmed mentoring relationship. And so some of the pain points, if you do have a claim, we absorb on claims where a mentoring relationship was in place. If you're the mentor and somebody then turns and tries to sue you, check out our mentoring page because we make it easier to serve as a formal mentor as long as you have followed some very, very basic steps which are described online. So in terms of the mentoring, we've mentioned some of the groups that apply to family law. We've mentioned also different communities. Another couple of communities that I think are really important to engage in if you're in family law. One is the Family Lawyers Association, because they are a great network of people, and also because they support CPD in this area in a timely manner. And LawPro has had a lovely relationship with both the FLA and 311 Jarvis, which was a court-based CPD program with the judges as well as the local bar putting it together. And through the pandemic, it's gone to Zoom. We've spoken, and there have been hundreds of people at these programs that really get into the weeds about what you need to know, whether it's how to make your case online or whatever the next issue of the day is. And you'll hear from both the bench and bar. So there are lots of places for you to reach out, meet people, gain substantive expertise. If you're in a firm, there are also lots of ways to do the mentoring. So Jennifer, maybe you can talk about some of the things you've implemented since the start of the pandemic to make sure that those lines remain open.
Yeah, so before the pandemic, we all worked remotely, but for the most part, people were in the office and we were able to meet, at scheduled meetings or informally. With the pandemic, we switched to Microsoft 365 and took on Teams, and we have a weekly Teams meeting where, it's not mandatory, but people can drop in, ask questions of each other. And we also have our own CPD program within the firm where, maybe once a month or quarterly, we'll, myself or my partner or another lawyer, senior lawyer, will do a presentation on a particular area of law, and people can ask questions, and there's also a social component to it. And obviously, we all are on Teams, which has a chat function as well. So people can always, communicate with me and say, I have a question. Do you have 5 minutes? And then we're instantly on video. So it's wonderful.
And, Teams is great too, because many of these live platforms, whether it's Slack or Teams or Google's equivalent, you can send emojis, right? And that's really important. A little bit of humor. I did see a case once where it turned on an emoji at the end of a sentence, which somebody said they were mad at the time, but they sent a smiley face 5 minutes before the so-called, disaster struck. And that was the end of their case. It was emoji that won the case. But
you know what, Judah, you're really touching on something that's actually important. And that's like, humor and supporting each other, because this work is so stressful. And so if you can bring some of that into your firm culture or your practice, I think that's really helpful, even if it's just an emoji.
I know one group that has set up a WhatsApp network. And so if they know that somebody's going to court that day, even if it's online court, they send them little clips and like celebration and say, you've got this, we're all cheering in the background sort of stuff. And that helps, that sets a morale. It makes you feel supported. It means that that, you're part of a team, and it can feel wonderful. Michael, I think you wanted to jump in there for a second.
No, I was just trying to make a bad joke that may not have come through, so it's okay.
Oh, saved by Zoom, I suppose. All right. Well, I think that's an important piece is that, in the time of social isolation, I know everyone's been dealing with it differently, but trying to find that humanity in your practice with colleagues is an important piece, be it as if you're a true solo, find your groups. If you're in a firm, find your peers in your firm, but also find outside, right? There are lots of different places where you can find some joy through the social aspect of the practice. So we're getting up to about half an hour into the meat of the program. We've talked about some of the key risk trends we're seeing, and now we're going to focus for about the next 20 minutes or so on the single biggest one. Our big theme number 2 for today is around client management and client expectations, because the client part, right? We're in professional services. The service part is for a client. That's the big sticky point for lawyers across almost all practice areas, the number one issue. Kelly, you're coming off of speaking at and chairing the Family Law Summit for the Law Society, and you're no stranger to this area. Why don't you lead us by kicking it off?
So actually, client management of client expectations is my favorite part of family law, actually. And I know a lot of lawyers will say they don't like that part of family law. They want to practice the law part, but I love helping a client understand their situation and the risks and the hurdles, as well as what their own personal objectives are. So in terms of managing clients' expectations, my advice is start early and don't stop. It starts when you meet the client, and it is a continual process that continues. And as you were discussing, it shouldn't be a judge that is managing a client's expectations. That's way too far down the road. So I do a couple of very practical things. So first of all, I don't do free initial consultations, and I don't think any family law lawyer should. This is probably where you're putting in the most effort and managing clients' expectations the most. You should be paid for it, and you should do a good job of it. It shouldn't be a half-hour consultation. So it's a very important piece, because you're dealing with the limitation periods, you're assessing risks, you're dealing with preservation of assets. Those things start in the initial consultation. So I do something that I find kind of fun. It's very hard when you're note-taking to take notes of what you're telling a client. So at the end of, because you're taking down, date of marriage, date of separation, what's happening, but you're taking notes about what they're telling you. So at the end of my initial consultations, I write a section that's called advice, just in point form. And it's an opportunity for me to repeat to the client at the conclusion of the consultation what advice I gave, just in point form, and I show it to them. I write on yellow paper, and so I always have advice at the bottom, and it will say limitation period, spousal support, mid to high range, property division, no deduction for the inheritance that went into the matrimonial home, and I show it to the client, and it's usually quite specific. Then I show it to the client again. So we're preparing for the case conference. I say, remember, I told you in the initial consultation this, remember, here it is on my yellow paper. And then that manages their expectations throughout. And even at the end of the case, I'll say, see, we've settled, it's within the range that I suggested at the beginning. Now, you're not always entirely right, so it can't be 100% perfect, but it's a way of early on starting to manage the client's expectations.
You know, Kelly, it's really impressive to hear that as a novice. I worked in firms where if you brought in a family law file, you were fired. Like they did not touch this area, and they knew, stick to their lanes, right? Do not touch criminal, do not touch family. But what you're talking about describes some of the work that groups like LAWPRO insist upon. We require counsel to assess a case up front and to let us know, warts and all, what's going on a file. And if things change, we just get an update that things have changed. But that allows us on the back end as a client to make decisions in an informed way. But it forces the thinking up front, and it forces the client expectation up front, because nobody wants to hear that, hey, come on in, I'll help you, I will solve all your problems, and be sold a false bill of goods only to see time and money flutter away to get nowhere near some unrealistic promise that the lawyer will just make it all go away. Jennifer, wondering if you've how you manage that intake process and managing the expectations.
Yeah, I'm very clear with my client, just adding to what you were discussing. And a frequent line I have is, my job is not to tell you what you want to hear. And, I have a case right now with a client, and every time I chat with her, she's very angry about her situation. And she's trying to get me to help her, and advocate for her. But I have to tell her at the end of the day, her expectations are not reasonable. They're not realistic. I have to give her an assessment of what her likelihood of success would be in court, which we know is often unpredictable. I think also, I agree with Kelly, I also love the communication client relationship piece of this work. And that's so important. And it's taken me a number of years to really be good at it, and to learn sort of the hard way from past mistakes with client relationships. And I guess some tips I'd want to share would be prompt and good communication. Even if you're really busy, you can always have your assistant or clerk maybe reach out to them and schedule a call in the future. At least then they know their email or message was not ignored or fell into the void. We already discussed educating clients, and I saw someone in the chat talked about working with clients who are coping with trauma and being mindful of that yourself as a lawyer, and also pointing clients to resources so that they can also educate themselves, or resources that reinforce what you've already discussed. Dealing with your own triggers as well as the client's triggers. That's tricky. I mean, as lawyers, I have a bit of a temper sometimes. And so, if I get an email that's, borderline offensive, I can feel, get my back up, and there's a temptation to respond immediately. And I've learned to take time to calm down, and put further thought into this before responding to triggers, and also understand your, things that are triggering your client. It could be other counsel's emails and letters that are triggering your client. Know that's going to happen. And, always give your client an opportunity to calm themselves, to think things over, and give you instructions that, perhaps are more reasonable than their initial reaction. And really simple tip, avoid the last minute work. Don't wait to the last day to file your brief. You're adding to your client's stress. You're risking that the brief won't be accepted for filing in this day and age and won't get to the judge. That's entirely embarrassing, and putting more stress on an already stressed client. Not a good plan. And empathy. So much to say about this, but there is a way to empathize without going too far or being too emotional, so getting yourself too emotionally wrapped up in the client's case, over identifying with client. Their life is not your life, but you can still empathize, understand what they're going through, acknowledging it, and working with them in a way where you can maintain your own boundaries and stay intact yourself and well yourself.
You know, Jennifer raises two really important points on the client management, which makes you a better lawyer. It'll make you a better lawyer for your clients and allow you to have that constant objectivity and joy as well in the work you do. And one is, you know, on the boundary side. And Jennifer mentioned trauma, and I think it's a piece we need to recognize. It can be difficult sometimes, even if you love your clients, even if you love the work you do, it can be difficult to hear some of these stories day in, day out. It can be hard to live with some of the burden that you've taken on behalf of clients. So you need to be able to create those boundaries, but they do impact you. So if you're wanting to learn more about this area, Mayana McCallum has the Trauma Informed podcast, which is excellent. And I encourage you all to try an episode or two. There are tons of resources she has. She also has a trauma-informed toolkit for lawyers that you can download. It's wonderful and helpful. You will realize that some of the things you're experiencing as a lawyer are human. We are human after all, and they are understandable. And knowing those triggers and knowing what your body is telling you, knowing those responses will help you become better at managing these tricky situations. The other piece I was going to mention about the lawyer client boundary is Jennifer mentioned the difficult conversation and time management. And we have seen cases where either the lawyer just never gives the bad news or waits and waits and waits. And I have seen this time and again where a lawyer knows there is a message that needs to be delivered and it is an uncomfortable one. It is easier in the long term to prepare for that conversation, take some notes for the conversation, give yourself time in advance of the conversation, allow yourself to breathe through in advance of having that meeting, deliver the bad news, go for a walk, stretch, breathe, and then write to confirm the instructions to your client. We've seen so many cases where because of fear, because of anger, because of whatever barriers, the message in an unfortunate outcome for a client has simply either never been delivered or there's been a misleading interpretation about what really went down because a lawyer was afraid of feeling the wrath or hurt or pain or whatever of a client. That can only do bad things for your client and ultimately for you. And we've seen many painful cases in family law based on that. Michael, you've got, I wanted to turn to you for sort of the last word on this area about the client management piece. From intake through to going away at the end of the day, what are some of the pieces that that you think you want to echo from what Kelly and Jennifer have said?
So the way I like to approach this is I'm not, I'm not a miracle. Somebody put it in the chat, but I agree. You're not a miracle worker. Okay, I'm just a lawyer. I can tell you what I think might happen. I can tell you what your legal rights and obligations are. I can give you advice about the best way to handle it, but I can't do much more than that. So I approach these things from the perspective of what is the end game? What is at the very beginning of the case? What is the end game? Okay, what are the range of reasonably likely outcomes? How much are those outcomes worth? I mean, your client doesn't care if you win the issue of should they be imputed with an income, but you don't get the amount of support that they need with which to live. Okay, they don't care who won what legal issues. They care how much money am I getting every month, how much capital am I going to have, and how often am I going to see my kids. And the range of outcomes in most cases is pretty obvious, pretty much from the get-go. I mean, one parent's not going to have the kids 100% of the time in the vast majority of cases. There's going to be some equitable, reasonable division. One parent's not going to end up with all of the money and the other one's going to get nothing. And, how much is it going to cost to litigate the case? I tell clients, quite frankly, I'm a tax. Okay. The end result in these cases is usually obvious. The question is, how much do you and your partner pay in tax to the lawyers before you get there? So I'm very blunt with people up front. And, if I think there's a problem, I will be clear about that up front. And, clients like to have direction. They're coming to you for advice. So you don't want to raise 1,000 problems and 1,000 issues that probably don't matter and say, well, this is an interesting issue, you know, and I don't know what a judge will decide, but I'm not going to mention to you that the issue is worth $5,000 to the winner, and who cares? You know, that I just look at it, you're restructuring a family into 2 households, and how do we get there? You know, and how much is it going to cost? That's what people really, I think, want to know. And if you're clear about that up front and throughout, you should, you know, most people will listen. And if they don't listen to your advice, they should go elsewhere.
I think Michael's hit it. I mean, cost, the time it's going to take to get to an outcome, and what the range of possible outcomes are the things people want to know. And Kelly, I think you had one comment you wanted to mention about costs as well.
Yeah, I did. Cost is a tough one because I'm always surprised at how much I cost, how much more I cost than I thought I was going to cost. And it's very easy to underestimate what it's going to cost for a case conference. For instance, you say, oh, it's only going to take me a couple hours to draft the brief and it's going to be an hour. So this case conference is going to cost you 3 hours of billings. In actual fact, when you go to do the case conference brief and you're distilling down and doing a chronology and a table, the case conference brief takes you the better part of a day. And then you're waiting in court, or the case conference goes longer, and you've only got a retainer for those 3 hours that you anticipated it would cost in the beginning. I think it's easy to undervalue ourselves and undervalue our time. So that's actually the area of managing clients' expectations around cost that I find the most challenging. And particularly for big things like trials, right? Like, it's hard to say this trial is going to cost you $15,000 a day in preparation and attendance. Sounds like an unbelievable amount, but our time is worth it, and we don't want to take shortcuts. So just really try not to underestimate costs.
You know, I think that's a really important part to close on when we talk about the client management. Is the bottom takeaway is that there should be no surprises for a client at any point, from intake to saying goodbye. And if there will be changes, but they can be managed. So everything should be in writing. Everything important should be in writing. Every key piece of advice and every estimate and bill should be going out in a timely manner. In terms of the costs, you are valuable. Your services are important. So you should make sure that you have set a fee that you are content with. You should be managing your time, docketing your time, explaining that time, and regularly showing the steps you have taken and why they were necessary and what value or necessary step they were contributing to in the family law matter. Those constant discussions can be difficult, of course. They can be painful for clients who are seeing their money go out the door, but it's important to remember that you did not create the legal problem. As Michael pointed out, your attacks. And so they are in a situation, they need your advice. You are providing a service, the service is value add. Make sure they understand that. And just remember that at the end of the day, some of these you will spend less time on, some of these you will spend more time. But as you develop your expertise, you'll get a better sense of how long things usually take and where you are wrong because you simply were completely off base. Usually when you go back to the assessment of what is a fair and reasonable amount to charge my client, which is what the rules of professional conduct talk about and what the courts talk about. What is reasonable is context specific, and you just have to have that conversation with the client. And sometimes that will involve shaving a bit of your time, but docket it first and then make sense of it after. And for sure, no lawyer bills 100% of their time on every file. So you want to be making sure you're thinking about the cost from the client perspective. Make sure they understand what they're going to be expecting in terms of costs from you. Make sure that if you thought, hey, if I was a client, when would I want a heads up that something's going to take a little longer, and plan accordingly. And one of the reasons to do this is it increases client happiness with you. But also, if we're talking about risks, when there are fee fights, you know, an assessment takes time and money. And complaints about fees take your time away from the work you want to be doing. And it's also, fees aren't something that LawPro covers. We're not there to fight fee disputes. That's how you've decided to arrange your billing. That's not about errors and omissions. So if you get into those sorts of fights, we're not there. But what we do see sometimes is people start by being really frustrated about fees, and then they dress it up into a negligence claim. And then you're reporting to LawPro, and then, you know, there's a big fight when it might have been avoidable had you been upfront and making sure that fees were fair and reasonable throughout. So we're going to turn now to some of the other practice management pieces, because things are going fast right now. We know that the courts are online, there's case lines, there's filing, there's limitations periods. For limitations periods, by the way, Practice Pro has a chart online. So go check it out, because you should be reviewing that at least once every 6 months or so to remind yourself of those key deadlines, because that's a real pain point for where mistakes happen. But when we talk about things happening fast and furious, one of the areas is fraud. And family lawyers are targeted. I don't care if you're a solo lawyer or part of a 500 lawyer firm, you're a small business, or maybe a not so small business, you are being targeted. You're also being targeted because you have a trust account. People are looking at lawyers to either wash money or try to get money out of your trust and replacing it with fake money that the bank eventually is going to say is not good tender, even though you're stuck holding it. This used to happen mostly, if not exclusively, by bad check frauds. And we'd have people, for example, get somebody to say, hey, I'm wrapping up my separation. I just need a lawyer to help me with the final little enforcement. There's about 30 grand that's owing. Can you just write the other side to this address? And lo and behold, within like 7 days of you writing a letter, a check shows up. And that check is a forged check. It's a bad check. And that bad check, you then are going to get pushed to cash it out as soon as possible. If you don't hang on to it long enough, the bank won't spot it. You cash out, you're stuck with a deficit. And, you know, LawPro covers part of that in certain circumstances, but we insist that you hang on to that check for a minimum period or get a confirmation from a bank that you are good to release the funds. We still are seeing bad check frauds come, and you can see a full description of family law bad checks at our blog, avoidaclaim.com. We describe all the different types of check and area of practice frauds out there. But the other piece we see, and sometimes it's targeted to family law, sometimes it's more generic, but we see cybercrime. We are seeing cyber breaches, we're seeing phishing efforts to get into your system, and we're seeing wire diversion scams where people who might appear even to be your client are saying, hey, here's a change on where this money should be sent. And of course, it's a diversion to a fraudster's account. And so there's a lot of danger out there. Kelly, I know you've had to experience some of this in your practice. Why don't you tell us a little bit about what happened to you and your takeaways?
Yeah, I mean, it's funny because so our firm was, we did fall for a phishing exercise. I'll tell you how it sort of happened, because it's quite interesting, because it's a phishing, it's our insurance company that was successfully phished that led to us being phished. So we got my office manager got an email from our insurance company enclosing an invoice. It was legitimately from our insurance company, because our insurance company had been breached, and they had, from the internal email, sent us a phony invoice right at the time that we were expecting an invoice. So it was very sophisticated, and we were specifically targeted. They knew we were expecting an attachment. They sent it. She clicks on it. It asks her for her Office 365 email to open the attachment. Looks all legitimate. Of course, you should never obviously enter your password, but she did. And the irony of it is that she was in charge of security and IT for the firm and was quite like knowledgeable. She went home. It didn't, when she opened the attachment, it didn't open properly. Or she went home. It happened right at the end of the day too. And sometimes I think they target specific times, either early in the morning or the end of the day when you're rushed. And she was thinking about it all overnight. She thought, I think, did I enter my password? So she came in the morning and she immediately changed her password. And we checked and we were able to see that someone had been logged into her email for, about 12 hours. And so the phishing, so the same thing that had happened to our insurance company that targeted us allowed her to be breached. In her email, or in her Office 365 email, you can imagine there's like 10,000 messages. We were able, though, we had to hire an expert. We were able to determine that they hadn't sent phishing emails yet from her email. And so we were able to determine that some of the privacy issues hadn't been breached. But I had to hire a lawyer. We had to learn that there are reporting obligations under privacy legislation. It was an incredibly challenging thing and easy to do. So my one piece of advice is, it's not just for the lawyers on this program to understand about phishing and malware and ransomware, and you need to really educate all your staff too, because they're just trying to do their jobs as quickly as they can in more isolated circumstances. It's very easy to fall for, please go and buy me some gift cards at Shoppers Drug Mart, which my law clerk also fell for one time. So it's very easy in these isolated circumstances. So educate your staff, make sure the whole firm is aware of these risks.
If you are looking for somewhere to learn more about this, because what Kelly experienced, let's just break it down for a second, and then I'll tell you where to go for more. Kelly's cyber attack was actually one of the good stories, because they got breached, which is unfortunate, but no client data was lost. Nothing went out of the shop. They were able to shut it down early. But you might be wondering, why did the cyber criminal wait? And the reason is because at some point, chances are that cyber criminal was going to sit on a file where Kelly was going to settle for big bucks with somebody. And then somebody was going to send something from inside her house to the other side to say, for this one, the client insists on a wire payment. Please send it to this address. And bam, it's gone. And without extreme luck, that money is gone at that point. And so we ask people to call before they click. Even if money is being sent from somebody you know, call to the other side if it's a wire. Call from the posted number on their website, not from whatever somebody has emailed you. Oh, just call me on my cell. Because if that email has been breached, none of the information you're getting, even if it's from inside the firm, can be trusted anymore. And we are seeing a lot of this activity right now. It ramped up so fast that we launched a program in December of last year, and it's available on replay at practicepro.ca/CPD. It's our Wire Fraud Nightmare event. We had 1,100 people show up to watch it live. We had whole law firms attend, law clerks and everyone. We had one firm that saved over $400,000 from going out to a wrong account because a law clerk had watched the program. So when Kelly says everyone needs to know, she's absolutely right. Everyone in the firm needs the training. I'd recommend you start by asking everyone in the firm to watch that program. It's an hour and a half. And for those who are lawyers watching this program, it's eligible for CPD. It's also eligible for the LAWPRO risk management credit. Start there, and then you can assess how up to speed are we? How much did we know about this? What other testing or other services might we need? The other thing we're going to talk about in that program, which I encourage you to watch, is that there is some coverage for some types of cyber breaches, but not all. So Kelly, for example, was breached, but it wasn't a professional error. It wasn't a liability issue for a client. These were costs that if she doesn't have insurance that covers it, are going to be assumed by her. There are now cyber liability insurance products. Some might not have been available at the time this happened to Kelly, but now there are other products available on the market that at times can refer you to penetration testing or to experts for forensics, or include those costs in some of the services they provide. And so you want to look around to see what sort of prevention is available beyond what LawPro is able to provide as a first base in terms of education, in terms of limited coverage, and think carefully about what your business risks are in the cyber era. So Kelly, thank you for being so candid about what your firm experienced. You know, the gift card hacks, the phishing attacks, the breaches, the wire fraud setups, these are real business risks for you right now. The good news is that technology also has its positives, right? And so we're going to spend a little bit of time to close out the substantive part of this program by talking a little bit about some of the tech that we have. You know, I think let's start first about how we're all in that pivot point. You know, everyone had their practices. It didn't matter whether, even if you were fully paperless, COVID impacted your processes. And when we get out of the pandemic, which we all pray is sooner rather than later, we're going to get into a next normal. And it's not going to look like February 2020. And it's not going to look like this MacGyvering of tech and old processes. We're going to focus again on our processes to try to build our next best level. So we're all in it right now. And we've seen some errors at LawPro, by the way, where there have been fumbles, and that's understandable. You know, if a clerk doesn't know what to do with a check that came into an office when everyone's remote, you know, and the check goes missing, or where somebody takes the file home on their laptop, but forgets that not everything's been scanned into the system yet, and then gives an illegal opinion. We've seen these sorts of fumbles along the way. Jennifer, I know that your firm has gone through a pretty significant tech shift right now. Why don't you tell us a little bit about how that experience went and what people can be expecting?
Yeah, I'd be happy to share. We recently changed our practice management software, which encompasses file management, calendar, and our accounting. And so we switched to another program. And when I first started, there were only like 1 or 2 programs available for this, but this is certainly a growth area. I think we're starting to see a lot more of innovation and legal tech, and I find that very exciting. I'm really looking forward to seeing where that goes, both for clients and lawyers. So if you are thinking of changing practice management software, do your research. Ensure that it's compliant with the requirements of the Law Society, particularly around accounting. And also go with a program that is going to be very supportive during the transition, so that you're not going to be encountering blackout period, lost data, all of those situations, that there are contingencies in place or overlap as you change from one program to another. Ensure that the program has adequate support and how quickly they're going to get back to you if you encounter a problem. And so, we recently switched to Ghost Practice. It's probably not the most popular software out there, but it suited our needs. And we found the transition, while stressful, because there's a lot of things to check over and reports to review, it went well. But there's always risk in that when you're doing that. And so really just make sure you carve out enough time to do the research, to deal with the transition, and to deal with any problems that may occur. The other, we have always used DivorceMate. We now use Microsoft 365. We have a new and improved firewall. Cybersecurity is an ongoing discussion at our firm, and we use Teams, the Teams chat, and video conference to flag emails that people are receiving. I received an email from so-and-so that looks suspicious, or Jennifer, did you actually send this email? I'm hearing from you, Judah, that Teams could also be hacked. So maybe pick up the phone, right? Or text somebody at the firm to double check. But yeah, that basically sums up the software we use. Yeah.
Those are a lot of great tips for implementation. And one of the things that you should know, if you're relatively new to this or you haven't built out a tech deck yet for your practice, it is easier to start than to pivot from one system to another. So if you're starting fresh, it's kind of fun because you get to build, it's a choose your own adventure here. And it's a shorter read. If you've got one big system and it's a legacy system, it's just harder to import. And so Jennifer's absolutely right. If you're looking at making a switch, that is a big investment. So that's really important. Either way, you need to get it done by finding what works for you. And there are a couple of aids that will help get you there. One that we'll put in the chat function, but it's also a link from the program materials, and you can find it from Practice Pro in the technology section, is we have developed a technology products for lawyers and law firms chart. And although we don't, give a stamp of approval on any of these programs, we've listed some of the programs that we have heard from lawyers by area of practice they are using. And so you've got lists of different general practice management programs, other file management programs, and we even have recently updated to include area of law. And for family law, we include DivorceMate, which is a very powerful tool. We've also included Setify, which is one of the tools available to help with client intake straight from your website. Some firms in Ontario are turning to it. Others can build their own. Clio, for example, just to name one, and this isn't a formal endorsement or anything, but just as an example, Clio also has Clio Grow, where you can create your own intake forms and your own specific forms. So Kelly, for example, has her intake where she's got certain questions she's asking. If Kelly was completely virtual and Kelly wanted to do this off of her laptop exclusively, she could have a set form where there could be input fields to help her make sure she's not missing things along the way, and where there could be even areas where you can add more data that may not be captured under your general questions. When you've got that curveball, as every client is going to throw you, you want some space where you can make sure that it gets addressed as well. So lots of different opportunities, whether you're a stay-at-home work from the basement sort of guy, or whether you're back in the office using tech, there's lots out there to support you right now. Just wondering, in terms of your experiences so far with the online filing in courts, what are a few takeaways? I'm going to go around the group, but let me start by saying, get yourself a great license of Adobe. One where you can put documents together, one where you can merge documents, you can set table of contents, you can hyperlink. There are some other pieces if you're regularly needing to cite documents. SiteWrite, which was developed through the Ryerson Legal Innovation Zone, has some really powerful tools that will automatically generate books of authorities, hyperlink to your cases, works with Canly and others. Really fascinating, amazing technology that takes us away from the days where I was summaring and literally taking a highlight to 9 copies of a submission going to a Supreme Court. Those days are over, and thankfully so. So in terms of the tech, what's working, what's not? Kelly, let's start with you.
We're sort of completely cloud-based now. Luckily, we did that prior to February 2020. So that was kind of lucky. And I just want to make one plug that gets back to our earlier comment. With the increased use of cloud for file management, et cetera, and people working from home, like cybersecurity is even more important, because if you're allowing people to put passwords to access your online files from their laptops at home, and they're memorizing those passwords on their laptops, and their laptop gets stolen, you have a very serious problem. So just to get back to our other issue, I'm using, in terms of software products that I'm using, we do use Setify for intakes. If the client chooses to do that. I know, Michael, your firm does as well. It doesn't happen in every case. It's not mandatory that the client uses that app to enter their intake, but I'm using it with good success. And they work with small and solo firms and target them and have special arrangements, financial fee arrangements for the small firms.
And Michael, how are you finding the tech these days, other than the occasional hiccup on your home Wi-Fi?
I don't miss fax machines. I don't miss having clients have to drive to my office to swear an affidavit. So this has all been fantastic, I think. I mean, there's certainly hiccups, you know. We had a file the other day where it took my assistant, I think, 3 or 4 tries to get it filed, get a document filed, and it wasn't sort of, I don't think it related to what we had done, but maybe some of them did. But that'll all get sorted out, hopefully, with time, because, you know, for whatever problems there are, you know, this was done sort of on the fly during a pandemic. So I think it's a vast improvement. And hopefully we'll get to the point where you can literally pull up anything you want online. Obviously, we're not there yet, but I think this has been, problems aside, I think this has been, you know, probably the most, what's happened here has probably been the most significant development to access to justice and, you know, forward progress in the legal system. And I don't know how, since I've been practicing for sure, but probably longer than that.
Oh, Michael, that sounds about right. I mean, regardless of your political beliefs, you know, our Attorney General has mentioned that the first 25 days of COVID marked about more progress on our court system than the last 25 years. And I think, giving credit where it's due, that's accurate. We've fundamentally changed the courthouse from a place to a service, and you know, making sure that it could continue to operate to serve the public, even if its bricks and mortar were no longer accessible to anyone through parts of this pandemic. And so, you know, I think that your optimism and I think your empathy about where things are at in terms of court filing is to be commended. And I think we can all take a page of that. I know there are some issues right now with the filing as clerks are trying to develop the quality assurance and make sure that that things are being accepted in sort of a consistent way. I've heard there are some rumblings that some things are being rejected here and there. Stay with us through that, because I'm sure that's all going to get better over time. As Michael says, we're all building this new ship through a pandemic. So some deep empathy is really welcome. And with that, I just want to thank everyone and just go through a little bit of some of the logistics to close out for today. I know some people have been asking about the credits that this program is eligible for. So let me be clear, this is eligible for 1.5 hours of professionalism for your Law Society CPD. It's also eligible for LawPro's risk management credit. You can claim that credit at lawpro.ca. This program is also going to be available as a replay on practicepro.ca's CPD webpage. And so you can return to some of this video. You can share it with colleagues who may have missed today's session, and they can watch it at a time that works for them in this very hectic period. When the replay is ready, we'll send out a post via avoidaclaim.com. That's our blog. If you want to be in the know, you can subscribe for updates there. And you'll also get regular updates with practice management tips and fraud prevention. For example, Tuesday was the first in a series of time management tips that I'll be sharing via Avoid a Claim. Then you can subscribe there. They'll come straight to your inbox. A reminder to save the dates. We are continuing with this Thursday tip series with Toronto Lawyers Association, Thursday, May 12th, with tips for advocates. And that's for everyone from civil through to criminal litigation, you name it. If you're an advocate, we hope to see you there. Then on Thursday, June 9th, we'll be meeting again for tips for wills and estates lawyers. We hope you'll consider joining us and tell your colleagues as well. Some thank yous before we end today. I want to thank our speakers, all of you, for sharing your time and expertise and your candor with us today. To the Toronto Lawyers Association, as always, Joan, Deirdre Harrington, Sandra Porter, Stephanie Lang, and the entire team, thank you so much for being such a great partner to work with to deliver these key messages. Thank you to Ontario's law associations for spreading news of this event, as well as specifically the Family Lawyers Association and the organizers of 311 Jarvis CPD, events. Thank you for sharing the information about today's events with your communities. We really value your partnership to allow today's session to go so smoothly and to be so well attended. Over at LawPro, thanks to the entire team. Special thanks to Yvonne for stepping up and being a part of today's program. And help us. You're going to be receiving an email from the Toronto Lawyers Association for the program evaluation. We ask you to please complete it. It's going to help both the Toronto Lawyers Association and us over at LawPro develop timely, helpful programming to help you. And if you've got other comments you'd like to share or just want to reach out, you can give us a shout at practicepro@lawpro.ca. So that concludes our program today. I want to thank you again for taking the time to be with us. All the best and stay safe.